Hello, everyone. I'm Jeff Hampton with the Hampton Law Firm. Today, I want to talk to you about burglary charges in Texas. What is the law? What are some defenses to consider? And what should you do if you're facing a charge of burglary in Texas? By the way, if you wait around to the end of this video, I'll also send you a free ebook, What to Do If You Are Charged with a Crime in Texas. And if you enjoy what you hear today, I encourage you to subscribe to our YouTube channel. We've got many other videos that cover everything related to criminal defense for every question you might have. Okay, so today let's talk a little bit about Texas burglary charges. Now, there's different types of burglary that can qualify as a misdemeanor. For instance, burglary of a motor vehicle or burglary of a coin-operated machine. And I'm not going to spend a whole lot of time talking about those today. For the most part, most burglaries involve a felony charge. It's a felony offense, whether it's a burglary of a building or a burglary of a habitation. And so as a result of that, most burglaries you think of are associated with theft, right? Somebody trying to break into something to steal something. But there are other examples. You can actually be charged with burglary if you were trying to enter into a residence or a building with the intent of trying to assault someone, right? Trying to break in there in order to get into an assault situation. But we're going to spend a few minutes defining burglary. What does Texas law say burglary actually is? Well, under Texas Penal Code section 30.01 through section 30.07, it specifies that the charge of burglary applies when the defendant does one of the following without the effective consent of the owner. Number one, you can enter a dwelling, a building, or any portion of a building not open to the public with the intent to commit theft, which is what we talked about, assault, or any felony level offense. Number two, you remain concealed with the intent to commit theft, assault, or any felony level offense. When we say remain concealed, we mean you break in and you wait. You just sit there, and your intent was to commit this crime. Number three, enters a dwelling, building, or portion of a building not open to the public and commits or attempts to commit theft, assault, or felony level offense. Okay, I don't want to get caught in the legalese version of the definition of all of this. The point of it is you're entering into someone else's residence or a building with the intent to commit a felony or commit theft, right? Now, I did a whole other video series, actually did not a series, but another video about comparing robbery, theft, and burglary. And you can go back and take a look at that if you'd want to kind of get a viewpoint of the differences between them. And that's where most people tend to look at it. They try to grade burglary under a theft or a robbery comparison. But the better comparison is the difference between burglary and criminal trespass. Okay, so those are the two crimes that are more closely associated. And in order to successfully convict someone of burglary, the prosecution, here's where it's important. What does the state have to prove? They must prove beyond a reasonable doubt that the person being charged committed an unauthorized entry into a dwelling, building, or part of that building or dwelling without the owner's consent and with here's the key part, the intent, the specific intent to commit theft or another crime or another felony. So even if you didn't steal anything, some people say, well, I didn't even take anything. I went into the residence and this guy made up something saying he thought I was coming in here to steal something. I wasn't in here to steal anything. I was in here to confront someone or to talk to them or try to reason with them, right? Well, if the officer takes this other person's word and believes that you were there with the intent to steal something, you might not have walked out of there with anything, but you're still staring at a burglary charge. And if it's a residence of someone, it's a second-degree felony, punishable by up to 20 years in prison. So it's super important to understand that in this situation, unless the person actually made it out of the building or the residence with something, an item showing that they committed theft, in this situation, police officers and prosecution have a tendency to try to rely upon circumstantial evidence, right? Or a confession. So that's why whenever these sort of crimes come up, one of the first things a detective is trained to do is to try to get the person that's being investigated to sit down with them, see if they'll open up, talk to them, share their side of the story. In reality, what they're attempting to do is to try to see if this person will incriminate themselves so that they can actually make a burglary charge against them rather than a criminal trespass. So why does this matter? Well, here's the thing. A criminal trespass charge is a misdemeanor. Okay, so even a criminal trespass of a habitation, that's a Class A misdemeanor, punishable by up to a year in the county jail. But a burglary of a habitation, that's a second-degree felony, 2 to 20. Big difference, right? So it very much matters what the state has and what they can prove. So just as a quick aside, you say, what are the penalty ranges? If there is a burglary of a building, just a building, okay, not a residence, but a building, it's a state jail felony, punishable by up to 2 years, 6 months to 2 years in a state jail facility, and up to a $10,000 fine. And a burglary of a habitation is a second-degree felony, punishable by up to 2 to 20 years in prison and up to a $10,000 fine. You can end up having a more serious first-degree felony charge if there is with intent to commit assault, a burglary of a habitation with intent to commit assault, like sexual assault or an aggravated assault. That can make it a first-degree felony. Okay. Now, let's say they don't have any evidence. This is where I'm going to finish off with this video. If the police have very little or any evidence to establish what your real intent was, it is critical that you hire an attorney to make a presentation to the grand jury. The grand jury can do one of three things on your case. They can keep it as a felony. They could lower it to a lesser charge, say down to a criminal trespass, a misdemeanor, or no-bill the case. Okay, a no-bill basically is the equivalent of a dismissal. And so we find that many of these cases are extremely difficult to prove. And if you hire a good attorney that can investigate this matter prior to the grand jury hearing the evidence, you may be able to save yourself a lot of heartache and grief. And so you don't have to fight a second-degree felony. All right. Well, that's burglary. All right. That's a short overview of it. I could spend a lot more time speaking about it here. But if you need help with your specific set of facts, maybe you're facing a burglary charge now and you want to understand the law a little better, don't hesitate to contact the Hampton Law Firm at 817-877-5200. I also promised you if you waited around to the end of this video, I would give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Just click the link down below, input your email information. We'll be happy to send it over to you. And thanks again for joining us on our video today. I look forward to seeing you on our next series.